Will the clerk please open court?
The Supreme Court is now in session. The Honorable F. Philip Carmelita, Chief Justice, presiding.
Good morning, counsels. We are ready to proceed, and I'm going to ask our courtroom clerk to please call the case.
This is Supreme Court case number CVA20-001, Gerard A. Cruz, Plaintiff Appellee versus Carmelita C. Cruz, Defendant Appellant. Appearing for the Defendant Appellant is Attorney Nicole G. Cruz. Appearing for the Plaintiff Appellee is Attorney James M. Maher. The panel consists of Chief Justice F. Philip Carmelita, Associate Justice Robert J. Torres, and Justice Pro Tem John A. Manglona. Attorney Cruz reserves 7 minutes.
Thank you. Attorney Nicole Cruz, you are recognized.
Thank you very much. Mr. Chief Justice, Your Honors, good morning, and may it please the court. What should have been a divorce that was settled in November 2015 has now become an almost 6-year-long post-divorce litigation. The parties in this case were married for about 20 years. In that time frame, Mr. Cruz was able to rise to be the president and CEO of Community First Federal Credit Union, a financial institution here on Guam, with an income of $200,000 annually. Carmelita, a defendant appellant in this case, is working at Naval Base, earning $40,000 annually. Since the divorce, the parties entered a stipulated decree, and the grounds for it was adultery. When the parties entered in stipulated decree, Mr. Cruz admitted to fault to adultery and also provided offers in how to resolve the divorce. After the divorce was finalized, Mr. Cruz began piecemealing Carmelita Cruz's interest. And since then, there has been 8 decisions and orders that makes the stipulated decree today unrecognizable. The standard of review,
Miss Cruz, and I know we have a lot of Cruzes with Cruz versus Cruz and the attorney Cruz. So I'll call the attorneys by their first name as well. Nicole, I just want clarification in terms of the decision and orders that are up on appeal and exactly the scope of them. You have, of course, the February 11th, 2019 decision and order that disposed of the motion for contempt, the motion to enforce the decree, and the motion for the writ of execution and the judgment debtor exam. It appears that you've conceded that the decision on the order to show cause and contempt is not on appeal. And you also did not set forth anything in your briefing on the motion for the writ of execution and the judgment debtor exam. So it appears that at least on the February 11th, 2019 decision, the only thing that is up on appeal is the motion to enforce the decree. Is that right?
that's correct, Your Honor.
Okay, and then in following that, the motion for reconsideration of that order, which was denied in December of 2019. And then you have the September 8th, 2020 decision where you requested modification of the party settlement agreement, asking for $3,000 a month in spousal support, the awarding of the marital residence as a form of spousal support, and then the award of the money judgment of $88,500, right?
That's correct, Your Honor, and also attorney's fees.
Yes, and attorney's fees. Now, that first of all, with regards to attorney's fees, you seem to, in the brief, make an argument that some of the attorney's fees that were incurred in bringing the earlier motions, you talked about the 8 different motions, somehow should also be up on appeal, but you didn't take an appeal of any of those earlier orders, you know, that were issued, the March 15, 2017 decision, the August 2017 decision, the January 2018 decision. You didn't take up appeals on any of those orders previously, right?
That's correct, Your Honor. It's only going to be from the February 2019, December 2019, and the September 2020 decisions. Those other motions, Your Honor, and decisions in order, those are relevant in seeing why it is necessary for Carmelita Cruz to actually be awarded attorney's fees, because that would be the standard under the award for attorney's fees. And those facts are very relevant as to why it was necessary for her to file the serial motion, especially limiting to the motions from February, December 2019, and also the counter motion. And that was brought up in the counter motion because it was basically a summary of the whole history of the case and why it is necessary for Carmelita to receive the award for spousal support.
But you're not seeking fees for anything pre-2019, February 2019.
Yes, Your Honor.
Okay, and I wanted to just ask you a question as well about the jurisdiction. You cited in your jurisdictional statement that the court has jurisdiction over an appeal of a final judgment of divorce. So of course we do, but it's not the final judgment of divorce that we're reviewing here. And then you also cited 19 GCA 8414, which talks about appealable orders from disposition of community property. But that order for appeal of the community property order that was rendered should have been done within the time frame of appealing the final decree, right?
Yes, Your Honor.
So those really aren't relevant to the jurisdiction of this matter before us.
Yes, Your Honor. Well, this court has jurisdiction in reviewing appeals, in reviewing final judgment orders regarding divorce decree, and that's where the jurisdiction for this court is at. And there is a jurisdiction in regards to motion to enforce the decrees.
So you're really looking at then a question of an appeal of a order made after a judgment, not the judgment itself. So it's a different statutory basis of jurisdiction.
Yes, Your Honor.
You can proceed. Thank you.
Thank you very much, Your Honor. And so the standard of review in this case, and encompassing the review of the stipulated decree, as this court previously held in Scruggs and Lujan, the decisions interpreting consent decree and its underlying agreement are reviewed de novo, including divorce decrees incorporating settlement agreements, which we have here. One of the issues in this case is the money judgment for $88,500 as a result of Carmelita's loss of her separate property. In applying contract principles in the stipulated decree, Carmelita needs to be made whole. And this is something that was not accomplished in the February 11 decision, and also in the decision on the motion for reconsideration. And so Carmelita files her motion for reconsideration, and under Ward versus Rages, in order to satisfy that, there are three factors. There is either there are new material facts, there is a clearly erroneous ruling from the court, or a manifest injustice, or there's a new law. And in this case, Your Honor, there is a satisfaction of those two factors. There is new facts and there is manifest injustice in this case. So with the new facts, Carmelita was awarded her separate property under section 1B1 of the stipulated decree. This separate property was her inheritance from her parents. And because gifts are generally separate properties under Guam law, that is separate property. Additionally, it is clearly and ambiguously indicated in the stipulated decree that the separate property in Chalampago, that inheritance, is Carmelita's sole and separate property. Again, also, Mr. Cruz never disputes that fact, nor does the trial court. the trial court does acknowledge that that is Carmelita's separate property. And so when that was lost because there was no order for a remedy for at least the value of property or an order to redeem that property after the February 11 decision, it was then lost, Your Honor. And after that, there's also no indication in the record or in the decision and order from the lower court that Mr. Cruz actually benefited $100,000 windfall because he was now absolved of the Pfc loan that amounted about $100,000. So the manifest, those are the new facts that actually arose there because there was the loss of the property was lost in foreclosure. And actually the February 11 decision was issued 4 days before the right of the redemption expired. And knowing that Carmelita does not have the ability, nor was there an $88,500 award to redeem that property in the February 11 decision, it was lost. And so then the manifest injustice in this case, really, Your Honors, is what happened is that the separate property of Carmelita was used to pay for Gerard Cruz's separate debt, amounting about $100,000.
Attorney Cruz, in reference to that issue, the trial court seemed to indicate that since the Carmelita's separate property, Chalampago property, was used as a collateral for the existing loan at the time that the divorce decree was entered into, and that the parties knew that that was coming up, the balloon payment. It was amortized over, I think it was 20 years, but it matured in 5 years. That it seemed to imply that Carmelita should have specified in the divorce decree if she had no intention or would not consent that the property be continued to be used as a collateral for the balloon payment, either a refinance or in some way extension or entering into a new loan. Was that is that consistent with the principles of the separate property? I mean, the trial court seemed to indicate that it was more incumbent upon the parties to specify in the decree, and since it was silent, the trial court felt that it was only fair that that was an expectation of the parties. And you mentioned contract principles should be looked at. What are your thoughts on that?
Yes, Your Honor. So actually, that's where there is an abuse of discretion, Your Honor. In applying contract principles, the court does not look at only one term. It looks at the entire contract. And so when the provision of the Pfc loan indicates secured by Carmelita's property, that is a mere identifier, Your Honor. It's a descriptive term as the other debts were identified and under which loans these were or which banks they were. This was copied and pasted from the complaint exactly the way it was. And also, Your Honor, going back to where the distribution of the assets, it specifically indicated there that Carmelita's sole and separate property is that Chalampago property is not contingent upon anything. And that's why it would be illogical to think that there is going to be forever the use of separate property to secure Mr. Cruz's loan after they've already been divorced. So, Your Honor, in that case, that's where there is the abuse of discretion and the error in actually looking or interpreting that term. And so
if we were to be persuaded by your argument that the trial court erred in its conclusion that the Carmelita's separate property could continue to be used as a collateral for the new loan that Mr. Cruz was taking out, what's the remedy that is being sought on the part? The property is lost already, and so I assume that you're requesting for a money judgment to compensate your client for the lost separate property?
Yes, Your Honor, it would be the $88,500, and that was the approximate value or appraisal value of that property during the foreclosure.
So it's the market appraised value of what the property was appraised for at that time.
Yes, Your
Because
Honor.
there was some, I remember some evidence that the property was valued at $45,000. The loan that after all the deficiency judgment and everything was paid off was in excess of 100. So, but your position, it's the $80-some thousand of that it was appraised at the time that the new loan was being considered.
That's correct, Your Honor. And so
I'm interested more in reference to, if the justices don't mind, on your counter motion to modify the decree. Your motion contained 3 requests, and that's the court grant you, Carmelita, $3,000 per month in spousal support, the marital residence be awarded as a form of spousal support, and then the money judgment, as you mentioned, of $88,500 in the event that we find that the trial court erred in upholding or in finding that your client was at fault for the loss of the separate property. So in terms of the spousal support, you've properly laid out the legal standards in reference to the changed circumstances relating to support, assuming that we find that that spousal support request is a modifiable. There's a disagreement with you and Mr. Maher, but assuming that it is modifiable because it constitutes alimony support payments. The circumstances to warrant a modification is a material change in circumstances, both as to the requester and the person who is being requested of. And the court again found there that you, Carmelita, felt to satisfy her burden. She was the one requesting in reference to the changed circumstances. You presented evidence in terms of Carmelita's circumstances to why her circumstance changed from the time that the stipulated decree was entered until the time that you filed your motion. But I think more the issue has to do with Mr. Cruz and his circumstances. You seem to place the burden on him to come up with the evidence that his circumstances has not changed. I have a little problem with you shifting that burden in reference to showing a changed circumstance of Mr. Cruz.
So, Your Honor, Ms. Cruz, Carmelita Cruz, acknowledges that the burden is on her to show the substantial material changes in circumstances, and she met that burden. She provided her 2019 declaration in June and indicated all of her expenses. Immediately after that, she was diagnosed with stage 3 cancer, where then she started getting chemotherapy requiring at least $1,000 every 3 weeks for her chemotherapy treatments. On top of that, there are other expenses. She also further testified, Your Honor, that she is now relying on a donated leave program at her employment because she can no longer work. Her body is physically challenged because of the chemotherapy treatments and the condition she's in. And so, Your Honor, the burden is not being shifted to Mr. Cruz in that sense that Ms. Cruz actually established material change in circumstances.
I don't think that was the issue. The trial court didn't seem to have problems with Ms. Carmelita Cruz establishing her changed circumstance. What I think the problem was Mr. Cruz's changed circumstance from the time that the stipulated decree was entered. What evidence did you produce to show that his circumstances changed? You just said that he pointed to a 2016 declaration, and that was not sufficient. That is outdated. But what did you do to show that his circumstances changed such that he could he could afford to make these payments, which is where the trial court was coming from, and that it was different. His circumstances, his financial ability, and his expenses changed from the time that the stipulated decree was entered into. As I mentioned, it's two parts. It's the requester and it's the requested party changed circumstance. So what evidence was produced to establish that his circumstances changed?
So, Your Honor, we had evidentiary hearing on multiple dates after the filing of the motions, and Mr. Cruz took the stand as to regarding what his income is. He does acknowledge that he still has $200,000 in income from Community First alone as a president and CEO. And then he did also testify that he's remarried to his mistress, Letitia Lujan, who has businesses and also other assets. They also have a business together. He testified as to the laundromat, Crispy Clean, that isn't income generating. Those were things that were actually testified by Mr. Cruz during the evidentiary hearing. He did, however, did not want to testify as to what his expenses are, claiming that these are irrelevant and that these have been litigated for several times. But this is the point that why Ms. Cruz actually had to file a series of motions to enforce requesting attorney's fees and spousal support on several occasions, because of the inaction of Mr. Cruz and his ability to ignore the court's decisions and order, despite, for instance, in his separate debt obligation, there was 3 separate judgments and also a money judgment by the court requiring him to pay those debts, and yet it took him 4 years later to pay them. And so, Your Honor, there were testimony, and then the use of that 2016 declaration was completely irrelevant. And that's where the abuse of discretion is at, because that declaration was in no relation or in no involvement of this case, of this motion.
Just drilling down a little bit in reference to those general statements, that there were businesses that he co-owned with his second wife. I think there was some testimony about a laundromat, and that the second wife was earning approximately $40,000. But there was no drilling. I mean, I didn't see any deposition testimony or any subpoena to stake him up. Was that a profit-making venture? Was it operating at a loss? What evidence? Because we're although it's a de novo review in terms of any factual findings, we look at the trial court for any clear abuse of I don't know if it's an abuse of discretion or anyway, the standard in reference to the factual dispute. And the trial court was having problems in reference to just the general statements. And I didn't see any specific evidence to the contrary that would make the trial court's findings clearly erroneous. That's the term I was looking for. So these general statements that he had other businesses, and that really doesn't say much. Could have been operating at a loss, and he could have been subsidizing, especially during this period of time.
Your Honor, the fact that he admitted to a $200,000 income and refuses to testify.
But that income is no different from the time the stipulated decree was entered into. It has to be changed circumstances. And if he was earning $200,000 at the time the stipulated decree was entered into, and $200,000 at the time you filed your motion to modify the support payments, there's no changed circumstance.
And it was refusal, Your Honor, to answer those questions as to his income, and also his unwillingness to provide a declaration as to his income. It's those factors, Your Honor. And also, in regards to a subpoena ducis tecum, actually, Ms. Cruz requested for the PFC loan documents from PFC, and that was quashed by the court. That would have indicated what his actual income and assets would have been and how much the value of the property is going to be. And that's another point, Your Honor. And Your Honor, I believe I have only a few minutes, and I would like to briefly get into the point on the marital residence. And so under the marital residence, this court in Scruggs and Lujan actually provides whether it's allowable for this court to, or the trial court to modify the stipulated decree. In the first category, actually, Ms. Cruz does meet that burden in that she and that there is a separation between the assets, distribution of assets, because it's put on subsection C under all of the award for the separate property.
Cruz,
Yes,
if I
Your
may
Honor.
just, in your counter motion, you seem to be saying that some terms are not included in the stipulated decree, and they involved the marital family residence and also the use of Chalampago as security for the PFC loan. So, but I think of the trial court's December decision where it says the parties agreed that all the terms are included in the stipulated decree or the settlement agreement, all the terms and conditions. So you're saying that the terms and condition are not complete now because there's no division of the family residence as to what to do with the at least $100,000 in income there, and also that the property in Chalampago, as to that property, it wasn't stated that it cannot be used beyond the balloon period.
Your Honor, I believe all the terms, it is our position that all the terms are found in the stipulated decree. It's a matter of the interpretation of it. And so in the marital residence, this is why the marital residence is a form of spousal support. It does not award it to Ms. Cruz. It does not award it to Mr. Cruz, but Ms. Carmelita Cruz was residing in that property and the obligation was put on Mr. Cruz. Again, this divorce was based on admitted adultery. And so Mr. Cruz actually was required to make periodic payments, which is the monthly support. And that's why this marital residence provision is a form of spousal support. But even if this court finds that this is under the second category, as the trial court did, there is gross inequity in this case, Your Honor. Over the almost 6 years of litigation in this case, there has been distribution of assets that are not what the parties assented to. For instance, the separate property, that is clearly Ms. Cruz's sole and separate property, and that was used to be awarded and pay for the PFC loan. Another thing is, yes, Your Honor.
You try to argue initially and that the marital family residence was a form of support, and then your alternative argument, as you indicate, is that even if it was a community or property distribution and not support, that we can make an adjustment based on the gross inequity, and pointing to the money judgment or the lack of losing the separate property as a basis for the gross inequity. If we agree hypothetically with your position that your client is entitled to the $88,500 money judgment, doesn't that then undercut your theory that there's been gross inequity and we shouldn't follow the terms of the agreement for purposes of the distribution of the marital residence and the allocation of the property? Because as it is, your client got all the equity after the sale. So it was just to pay off the community debt associated with that mortgage. And so when you look at it and you point to 2C or 1C as saying, well, that indicates its support as opposed to the distribution of property. But the only reason it's there is because it seems is that because you're going to be paying the mortgage associated with that, which is a community debt, and because that's not listed anywhere else except for C. And then once that debt is paid, your client gets the equity after the sale.
I respectfully disagree, Your Honor. Actually, this is going to be the debt obligation is a sole and separate debt of Gerard Cruz. This was what he signed for when he entered a stipulated decree. And this is because it was adultery. And so, Your Honor, it won't be community debt.
Where is that indicated in the stipulated decree? Because when I look at C, it says the parties will list the home in Chalampago, and no less than 100,000 more than the balance of the mortgage on that sale. And in the event the house is sold, the defendant will obtain all the equity. So the where does it provide for him to have the debt in for that property?
It's under section 2A1, Your Honor.
2A1, okay.
Yes. And that indicates that he has a sole and separate obligation to pay for the marital residence.
But I think the point is, because your time is just about is up. The point is that at the time it was incurred, it was a community debt, but by virtue of the decree, it was then modified, changed to a separate debt. But at the time it was incurred, it was a community debt.
That's correct, Your Honor.
All right, so I'll get Justice Magnolia. Yeah, now I'll allow you to ask the final question before we ask Mr. Amar. She's already 7 minutes over.
I understand that there's, of course, a lot of disagreement between the time of the stipulated decree and the sale of the marital family residence. What was the time period between that? When was it finally sold? And because I understand that Mr. Cruz was paying was it $3,000 per month mortgage? And then he mentioned that was the reason he fell behind the Pfc loan payments and the other obligations that he was
Actually, Your Honor, that marital residence still hasn't been sold, and Miss Cruz remains to be in that property and living there. And so, Your Honor, thank you very much.
Can I ask one more question about this marital residence?
I'll give her another 4 or 5 minutes in rebuttal. And so at this time, I'll recognize Attorney Maher and Attorney Nicole Cruz. You'll get another 5 minutes in rebuttal. So Justice Torres will be able to finish his question.
Thank you very much, Your Honor.
Attorney Maher, you are recognized.
Thank you, Chief Justice, Justice Manglonia, Justice Torres. Just to clear up a statement made by appellant's counsel that Mr. Cruz refused to answer questions about his expenses or his income. That's simply untrue. I would direct the court's attention to ER 202 to 223. Mr. Cruz sat on the witness stand and was available to answer and did answer all relevant questions regarding his income and his expenses. I would note that appellant's counsel at the time actually didn't dispute any of the testimony that Mr. Cruz presented. So that's just simply not factually accurate. Now, working backwards from the arguments presented by appellant, the house has still not been sold. Mr. Cruz has paid well over $150,000 in mortgage payments. That issue is still pending below with the trial court. And Justice Manglonia is correct that one reason Mr. Cruz had a very difficult time meeting his obligations under the settlement agreement was he was paying for this house, which he anticipated would be sold in time. Now, as the court knows from the record,
Ms. Cruz seems to suggest that the stipulated decree provides that the debt is his separate property and that she gets all the proceeds from the sale.
well, that is correct, but he's still carrying this debt. It's a large debt he has to pay.
So what? Yeah, if he has to pay and carry that debt, why does that impact his ability to meet her obligations to her?
Because he has limited income, like all people do. As Judge La Morena found, his disposable income does not meet his debt load. And he was anticipating the sale of his house to relieve him of the obligation to pay that, whatever it is per month.
To
26
relieve him of what obligation? The debt on that house?
That's correct.
Yeah, but see, I understood Miss Cruz to say that none of that is supposed to pay for any of that debt.
I'm sorry.
Yeah, that was my question. Is Miss Cruz seemed to suggest, Nicole seemed to suggest that the marital residence, all of the proceeds were going to go to her client. And because it was a separate debt of your client, that none of the proceeds would be used to pay off the mortgage associated with that.
Well, that's correct. That's correct.
Well,
But
wait
he's-
a minute. Let me just, there's a difference between the equity and the proceeds of the sale. I mean, the
Yeah.
proceeds of the sale can go to pay for the mortgage, but the
That's
equity as a result of that, it's, as Justice Torres points out, is under the agreement, stipulated decree would go to Carmelita Cruz.
That's correct.
So you're saying that when the house is sold, you pay off the mortgage and then she gets the balance.
That's correct.
That seems to be a different interpretation than what Nicole has had, but we'll clarify that before. She thinks that because it's a separate debt of Mr. Cruz, he's entirely responsible for it. And when they sell the home, she gets to keep the entire amount.
Well, she gets to keep whatever equity there might be.
Okay, yeah, but yeah, that was the question I asked her, and she took a different position. But I'll ask her and get that cleared up in rebuttal.
Yeah, and of course, our position is this agreement is not modifiable, it's integrated. I've looked at the Lujan v. Lujan opinion, and I understand the Adams standard of 3 separate types of agreements, but I would direct the court's attention to the fact that there is the paragraph 1C, which references the marital residence, also is referenced by virtue of the mortgage in 2. I don't think the 2 can be separated. I don't think that a fair reading is that these are separate and therefore they can be modified. The same goes with the alimony. The words "in addition" come into section 3 about alimony. In addition is a word of inclusion. That preposition "in" is not one of severance or separability. It is one of inclusion, of incorporation. So our position is, based on this court's opinions, if it's not separable, then it requires a showing of gross inequity, or fraud. That's never been alleged here. So I'm sorry.
Yeah, let me ask you a question about the PFC loan. The description of the PFC loan to plaintiff as a sole and separate obligation, and it mentions the loan secured by the lot, the separate property, or what will end up being separate property of Ms. Cruz that was given to her by her father, and then describes the amount of the monthly payments. You allege that Gerard had a contractual right to finance the community debt with PFC and to pledge Carmelita's property pursuant to the agreement. But wasn't this a loan with PFC? I mean, there's no reference to the promissory note or the mortgage that is including it as part of this agreement. And wasn't the new loan that he was seeking not a modification or extension of the existing loan, but a brand new loan?
No, it's just refinancing. There's an extension. He sought an extension so that he could deal with it, and then he was seeking to refinance, which the parties had done on at least 2 separate occasions, which Judge LaMorena noted.
But Mr. Palmer, the extension expired, and the record, at least the way I read it, is that that this was a new loan that was being entered into. That's how Pacific Financial described it, because he was the only one on this new loan, or the second loan. And there was the extension that you are referencing which was for a period of whatever it was, 30, 90 days, had expired. And so I didn't see this as being an extension of the old loan. It was being entered into as a new loan, as a separate obligation of Mr. Cruz.
Well, it was not an extension of the loan. It was an extension of the payment period under the loan that he sought to give him time to refinance.
I really, well, that expired. I agree that there was
Okay.
this loan that was being entered into for the balloon payment amount plus the closing costs was not a modification of the first loan. The loan matured. Time to pay it off, and he was applying for a new loan in order to refinance that. And so it's a takeout loan to try and then pay the balloon payment and enter into a new loan for which he will be separately obligated to pay. And Carmelita, under the terms of the stipulated decree, was not to be made a party to that new loan.
Well, Justice Carmelita, the chronology was this. As we know, it was due in full payment June 5, 2017. Mr. Cruz sought to refinance, as he had done with his wife previously and successfully on 2 separate occasions. She failed to cooperate. She went essentially out of her way to frustrate that process. When it was clear to Mr. Cruz that he could not refinance as he was permitted under the loan, which was incorporated into the settlement agreement, he then on his own sought to get a new loan, which was rejected because they would not accept the security. The bank, Mr. Oladon, testified to this. They only wanted the security that they had on the original loan. So it's correct, he applied or he sought a new loan, but the loan that led to the default was the loan that he sought to refinance, which was the loan that Carmelita Cruz and Mr. Cruz had taken out in 2012.
Well, Mr. Maurer, I really think you should examine the record a little more closely, because the first loan matured, and there was a balloon payment that was due and owing. He didn't have the money, so he needed time to see how he could address that loan. And so he then worked out an extension of that loan to give him time to come up with the manner in which to repay that balloon payment. And I think, and Attorney Cruz can clarify, she didn't agree initially to the extension, but was concerned at some point and agreed to it. But by that time, already he had applied, which he had to. I mean, if the bank, an extension of the loan is the same terms and conditions as the old loan. The new loan, I don't know what evidence, was it amortized over 30 years? Was it going to mature in 3 to 8 years? That's a whole new loan. And so that now is the separate obligation of Mr. Cruz, which now we are examining whether it was reasonable for the trial court to require that the separate property under the divorce decree could be mandated to be used as a collateral for what was clearly a separate obligation on the part of Mr. Cruz. I didn't see anything in the agreement that mandated Carmelita Cruz to put up her separate property as collateral for the refinancing of the first loan.
And if I may add also, Mr. Maher, it's not that Gerald Cruz is not a novice in financing. He is a CEO of Community First, so he should know that there's a difference between the 5-year balloon and just the amortization for 30 years. These types of loans, I believe, they expire at the 5th year, right? So he knows that Justice Carmelita mentioned that there's a new loan that I think it was in the amount of $102,000 or $103,000. So he has to look for another collateral because that loan has already expired. So we're not dealing with a person here who is a novice in financing or loan agreements and the collateral that go under them.
Well, okay, he did look for alternative property, and it was rejected. From the creditor's point of view, the mortgagee, his property or their loan was secured by this separate property. So Mr. Cruz did all he could to prevent this from occurring, regardless of how we characterize it. But it was a community debt, as Chief Justice Carmelita noted.
But if he made every effort to refinance this, he could have paid the closing costs and attorney's fees, which according to the record is approximately $5,000, and that Pacific Financial was bound by its term sheet to then enter into this new loan with Mr. Cruz.
Well, of course, and that the court brings up a good point. There's been this characterization that he refused to pay it, but if the court were to look at the excerpts of record, the first one that was filed by Ms. Cruz on June 5th, 2020, if the court were to look at excerpt pages 251, when that question came up about this to Mr. Oladon from Mr. Areola, and did he ever indicate, I'm reading from line 6, and did he ever indicate to you that he did not have the money to pay the fees, as opposed to simply did not want to pay the fees? Now, it's a little bit awkward question, 2 questions in one. And Mr. Oladon said, based on this, no, he didn't state that. So there's been this narrative that somehow Mr. Cruz refused to pay for things. And when asked about that, Mr. Oladon said, no, Mr. Cruz never said that. I mean, that's the record.
Said what? I mean, I'm looking at that thing. Said what? That he didn't have the money or that he didn't want to pay? I mean, the answer to the question is not exactly clear to me either.
Well, it's ambiguous at best. I agree, but it certainly is not compelling evidence that Mr. Cruz categorically stated, I won't pay these fees.
Let me ask you this. Both parties look at Babalta and cite our prior decision in Babalta, where we held that a spouse who after separation, but before final decree, uses his or her separate funds to pay pre-existing community obligations is entitled to reimbursement for those expenses. Here, the foreclosure resulted in Carmelita's separate property being used to satisfy Gerard's separate obligation. And that was, of course, well after the divorce. Why should there be a distinction in terms of the entitlement to reimbursement from the party whose obligation was paid?
Well, I think the distinction I would draw is it wasn't used to pay. It was a creditor foreclosing on property that it was guaranteed through an agreement with both parties. So I don't think it's to pay. And by the same logic, Mr. Cruz, of course, he has paid a substantial amount of money for the mortgage on the house in which Mrs. Cruz lives. So he should be.
But he agreed. He agreed to incur that debt, Mr. Maher. That was he stipulated. And he entered to divorce decree. So I don't know necessarily if there's any more significance than he agreed to pay for that debt.
Well, and Mrs. Cruz pledged her property freely.
For the first loan, there's no question about that, but I'm trying to see where in the stipulated decree she agreed to use her separate property for the new loan that would be, or how whatever way Mr. Cruz was going to address the balloon payment on the first payment on the first loan. I don't see anything that counsel for Mr. Cruz said that in the divorce decree that the separate property after this divorce decree would continue to be available as a collateral for any new financial arrangement that will be necessary to take out the balloon payment.
Well, it's not, it's in the mortgage and the promissory note. And I think Judge LaMorena was correct. They'd been through this process before. It was Ms. Cruz who stifled it, who frustrated it, forcing Mr. Cruz then to seek a loan independent of her, which he couldn't because the bank wanted Mrs. Cruz's property, which had been pledged.
Well,
So-
other than those statements, I don't see any evidence in the record, and unless Ms. Cruz says otherwise, that is the case in terms of the note in the mortgage. But just stories, I apologize.
Yeah, I was going to say that even, I mean, obviously she had pledged the property. It was secured. The note was secured by the mortgage. There's no, I mean, the mortgage was secured by the property. There's no doubt about that. But when the PFC foreclosed upon the loan because he couldn't get the new loan, I still don't understand why we shouldn't account for the fact that the stipulated decree references that property as their separate property and the debt as Mr. Cruz's separate debt. So if even there's, I don't think anyone is disputing that PFC had the right to foreclose upon that property because it was a mortgage. But I don't think that just because they have that right, then transmutes that property somehow into a community property or a property that would then be able to satisfy a separate obligation. And that's, you know, essentially following up on Justice Carmelito's question, where does it allow the use or payment of her property to satisfy this separate obligation?
Well, all I can rely upon is Judge LaMorena's decision and order. He sets forth what happened as a factual matter regarding Mr. Cruz's efforts to refinance the extension, etc.
Well, yeah, go ahead.
Well, that's
yeah. Well, Judge LaMorena's order, interestingly, I mean, he seems the linchpin of that order is his belief that he only agreed to pay $1,880 a month based on the stipulated decree, that's all he agreed to do. And but if that's the case, then have they really then provided for a complete disposition of their assets and debts? I mean, if he's saying all that Mr. Cruz, Gerard agreed to do was to pay the $1,880 a month. I mean, isn't that the gist of why Judge LaMorena found that that he wasn't in willful default of the court's order, and that you know, he hadn't breached because that's all he agreed to do? And if that's the case, then are we saying that the agreement really didn't dispose of all their property and asset and debt?
As to that question, Justice Torres, you're correct. It doesn't. The marital residence is still in play. Mr. Cruz is still paying for it. And so the answer is no, this agreement did not dispose of the parties' debts and assets. And as to what Judge LaMorena found that Mr. Cruz, his income was, or his debts exceeded his income. And he found that Miss Cruz, and I'm talking about Carmelita Cruz, willfully frustrated Mr. Cruz's attempts to refinance the loan. That's the basis for finding that there wasn't any contempt. Yes.
Things, I mean, the property was foreclosed in 2017, right? Because of course, the failure to sign. But did Gerard expect, let's say that it was signed and closed in 2017, this new financing. Did Gerard expect that in 5 years later, the same Chalacadoc property would be used as security for another refinancing in, let's say, 2022. So it's, when will Ms. Cruz have access to this property free and clear? Is it for the next, 30 years from now or 25 years from now?
Justice Manglonia, the question, okay, that's a good question. I will have to say it's kind of irrelevant, and it was irrelevant for what Mr. Cruz thought about the property. It was the bank that was driving this. As to the second question, when would Ms. Cruz, Carmelita Cruz, have access to this property to use it? When the mortgage was paid, when it was fully satisfied. So much of what has happened in this case was driven by the bank's desires, by the bank's terms and conditions. Mr. Cruz, he attempted, in the testimony, it's in the excerpts, he attempted to find alternate property to substitute property so that he could relieve his ex-wife and she have the property. But it was PFC who nixed that, who said, no, we will not permit that. Now, obviously, they have FDIC regulations, all sorts of things that bind the bank. Why they did it, we don't know exactly. But we do know they said, no, we will not accept your alternate property. So much of what happened here was not Mr. Cruz's intention, his desire, or anything he did or didn't do.
I don't think necessarily our questions as finding ill motive, fault on that, that as a result, the foreclosure was because Mr. Cruz didn't use his best efforts to try and refinance this. Your client entered into a stipulated decree that said that the PFC loan would be his separate debt, and that it was maturing had a balloon payment that was coming up, and it was his obligation to refinance it. If he didn't have the ability to refinance it because he couldn't satisfy the terms and conditions, the consequence was the foreclosure on the separate property of of Carmelita Cruz. That doesn't mean that now the financial burden should fall on Carmelita Cruz because of those circumstances. I don't think that's what the meaning of separate debt and separate property mean in our code. And I don't see anything in the agreement that overrides, that the intention of the parties was when we say that Carmelita Cruz's Chalampago property would be her separate debt. Oh, and by the way, if Mr. Cruz can't refinance the PFC loan, it must be used as a collateral. And if that was the case, it should have been specified.
Well, okay. Inherent in this whole process was Mrs. Cruz's good faith efforts to cooperate. I mean, if she really didn't want her property to be sold and taken in foreclosure, all she had to do was cooperate. All she had to do was
but
that.
there was no requirement for her to give the mortgage.
Well, she put it in the settlement agreement. She agreed to that.
Where in the stipulated decree does she say that you can use my separate property for refinancing?
Let me find that. It is on, well, not refinancing.
You're not going to find it, Mr. Maher.
It's 2A2, the personal loan secured by, and that's lot number Chalampago.
Yeah,
so Mrs. Cruz,
that's just descriptive purposes. It's secured by that lot, and it references the amount, but it doesn't. There's no express agreement that he can continue to use that when the time comes for the payment of the obligation, which is his separate obligation. And in fact, that's why when you go back to Judge Lamorena's decision, the trial judge's decision, he relied on that as a basis to say that all it required Mr. Cruz to do was make the minimum monthly payments, and the property can continue to be collateral, so he could make those monthly payments. But I don't necessarily agree with that analysis, because the loan was going to be due by its terms, and when it came time for that loan to be due, there was an obligation to pay it. And that obligation, according to the settlement agreement, was a separate obligation of Gerard.
But he could not do it without her cooperation. The refinancing was impossible unless she cooperated, which required pledging her property as she had agreed to do in the settlement agreement. Those were the bank's terms. Those were not Mr. Cruz's terms. They were just following what they had done previously. And for what inexplicable reason, Mrs. Cruz refused to do what she had previously done on 2 separate occasions.
What was
As a
to
result,
prevent Mr. Cruz from paying it off himself using something else?
he had no money, Justice Torres. This was brought up before Judge La Morena. His debts exceeded, he took every debt.
But let's
From
say
there.
he had money and he paid it off. Then what would have happened?
Well, then
She
her
would have,
property,
she would have had the separate property entirely as her separate property, right?
that's correct.
So if it's his separate obligation and he had an obligation to pay it off, but he didn't have the money to pay it off, why should Miss Cruz lose her separate property?
Well, once again, she agreed to this and he only needed her cooperation. She made this choice. He didn't make this choice. If she really wanted to keep her property, all she had to do was cooperate as she had done previously. And I think Judge La Morena, he kind of threw up his hands as well. I mean, yeah, he said, I'm not unsympathetic to the fact that you lost family property here. But at the same time, you caused this. That's the fundamental problem here.
Well,
Nobody wins in a situation like that.
you seem to be reading terms into the stipulated decree that I'm trying to find in reference to the obligation of Carmelita Cruz to continue to use her separate property for a new loan in order to pay off the Pfc loan. I understand your argument. I'm just trying to find where it is expressed with the reference you read out that created an obligation for Ms. Cruz to continue to make her separate property available for the separate obligation of Mr. Cruz that he agreed to assume under the divorce decree. It's not clear to me. And you're saying that this is what the parties agreed to expressly. I just don't see that.
Well, I don't think
Mr.
there's
Maher, let's look at the language that you reference in 2A2. If the language ended personal finance company loan, period, and didn't have a reference to the security on that loan, would you say that she agreed to continue to use that property as collateral?
If that were omitted,
Yeah.
the
If
reference to the lot
it just
number,
I said the loan, yeah.
well, then it would be an unsecured loan by PFC.
No, why
That's
would
right.
it be unsecured? PFC's got the loan, they've got the security. But if that was deleted from the parties' agreement, what the parties agreed to does not affect PFC's at all.
Okay. I thought you meant just the loan itself. You're correct. No, if there was no reference, okay, in the settlement agreement, okay, that has no effect on PFC. I agree.
Right.
PFC, as I said, driving this whole process, they viewed this as a community debt and they were going to foreclose. And it was Mr. Cruz who sought to refinance. And because of
So
what
if
Mr. Cruz-
the language of the settlement agreement just said Pacific Security Loan and didn't even reference the security, would your position be that she still had an obligation to refinance that and use it as collateral with PFC?
Well, it'd be difficult to know what that would, it'd be so vague at that point what their obligations were. If she, in point of fact, if she wanted to save the property, she would cooperate. Now, in the absence of that language, she's in a better position to say, I don't have to cooperate because it's a separate debt. But that doesn't really address the underlying problem here, and that was her non-cooperation. And we do have the language that it was secured, which she agreed to, and she had done previously. So this was nothing new to Mrs. Cruz.
She didn't have to agree to that. That was the current state of affairs. It was secured by that note, but
And
I have
part
no
of,
further
Well,
question.
part of the
Well, I
difference,
think,
let me just say that when you said that there was no different circumstance, she was married to Mr. Cruz when she agreed to put up her separate property to secure a debt that she, the parties would benefit from. When this takeout loan now has to be entered into, they were divorced. They were divorced by a little over 2 years, as I recall. And so I think that was a little different circumstance in terms of the expectation on Mr. Carmelita Cruz. But do you have anything else, Mr. Cruz, that you want to summarize?
well, I think the testimony, if the court were to look at the excerpts, would see that Mrs. Cruz was aware and then flipped and flopped back and forth, saying that she didn't want her property used, and then said, well, I did cooperate. I did. So I think a fair reading of her testimony is that she did understand that to save that property, she would have to cooperate. Unfortunately, the bank moves with a timeline. And that's really what sent this off into the netherworld, because she just waited too long. And then in the last moment, she had buyer's remorse and said, oh my God, I better do something. It was too late. That's what happened here. Those are the facts in this case. So I have nothing more to add, Justice.
All right, thank you, Mr. Rauer. Attorney Nicole Cruz, I'll allow you a rebuttal of 5 minutes. And Justice Torres had a question before you sat down, and I'd like for him to finish that, and then you can continue using up your rebuttal time.
Yeah, I wanted clarification because it seemed that you suggested that it was his separate obligation and you were entitled to all of the proceeds from sale and not just the equity. And I didn't read the agreement that way, because the agreement specifically says that you get the equity after sale. And while it is a separate obligation, it remains his separate obligation in the agreement unless and until paid off with the sale of the marital family residence. So you ultimately are getting, or your client will get, all of the equity that remains after the mortgage is paid. But your position is that she wants the entire marital home without any corresponding community debt associated with it? You're muted, Nicole.
I apologize, Your Honor, for the confusion. I do agree with the court's interpretation of it that Carmelita would be entitled to the equity. What I meant when the confusion, I believe, is that when there is a request for the marital residence to be awarded for Ms. Cruz, but based on the stipulated decree, Ms. Cruz gets the entire equity, and that Mr. Cruz will continue to pay for the marital residence until that property is sold or paid off.
So but there's really nothing different than currently than is currently provided. So that's why I didn't really understand the request for the marital home to be provided to her, because ultimately that's what occurs under the stipulated decree. So I was wondering, what are you asking for differently than what is set forth in the decree with regards to the marital home?
Your Honor, I understand that it seems like it's status quo, but we are requesting for the marital residence to be awarded as her sole and separate property because of the history in this case, that there was continued piecemealing of every asset that there's that the parties have a connection with too. So
as her sole and separate property and not be used to satisfy any community debt? I mean,
yes.
Because so that's your position, is that you're going to get, if this property is worth $500,000 and the debt is $400,000, that he would take the debt as $400 and you'd keep the $500, and none of that amount would be used to satisfy the debt.
Yes, Your Honor, the reason is because of the gross inequity, because of the history of this case and how much attorney's fees she's actually have because of the continuous litigation since 2015.
But if we end up hypothetically agreeing with your money judgment, and so that ends up being awarded, let's say that's the case. I mean, that seemed to be the main basis for the inequity associated with it. And now you're going to rely on just the attorney's fees after February as being the gross inequity that warrants a modification of the property settlement agreement?
No, Your Honor. Actually, it's several factors. One of them is the separate property. And if there is an award for money judgment, yes, there is still that request for the marital residence to be awarded to Carmelita because of the other factors of the gross inequity. Your Honor, this is almost 6-year-long litigation. She has stage 3 cancer because there was no insurance provided to her. That's something that was taken away from her from the stipulated decree. Similarly, with this Section 2 debts, where Gerard promised to pay those debts after the final decree, those took at least 3 motions to enforce, and yet Mr. Cruz didn't want to pay them, continuously ignore the trial court's orders in that case. And those years, Your Honor, the effect on her physical health, her ability to work now, what has been taken away from her, and looking at the stipulated decree now, Your Honor, just taking a look at each section and asking, did Gerard get everything that he bargained for in this case? Yes, he did, and more. He was able to not pay for those debts for about 4 years. He also incurred a $100,000 windfall with a Pfc loan. Meanwhile, with Carmelita, looking at the stipulated decree, she's lost her separate property. She's had to incur this burden for over 6 years, having to pay out of pocket of what Gerard has promised to pay, did not have insurance, had to actually find out that she has insurance. She didn't have insurance at an appointment. Those things, Your Honor, are clearly indicated in the stipulated decree and were taken away from her. And the marital residence, Your Honor, this is the 3rd time. His last motion to sell the marital residence is Mr. Cruz's 3rd attempt to actually sell that residence, contrary to the terms of the stipulated decree and contrary to the previous finding of the court that this is now going to be sold for $574,000. So yes, Your Honor, that marital residence is still requested to be awarded to her as her sole and separate property. And the court—
Let me just say, Attorney Cruz, because that's a tall order, what you're asking. There's a lot of legal hurdles, and you're hanging your hat on that there's gross inequity in reference to the division of the marital residence. We have to view this at the time the agreement was entered into. That's the exception. Was there fraud or gross inequity at the time that the agreement was entered into? The marital residence was, your client was allowed to continue to live in there while Mr. Cruz was obligated to pay for the mortgage, and any equity as a result of the sale of the home would go to your client. So what's the gross inequity there?
On its face, Your Honor, there was no gross inequity. But what occurred here is that all these decisions in order created that gross inequity. And that's what's warranting.
That's why you're appealing. And that's what the court will be addressing. But in reference to the argument that the marital residence was not a division of property at the time the decree was entered into. Number one, you have to overcome that. It seems fairly clear. And number two, it's subject to the exception if it was. And to me, we have to view that at the time the agreement was entered into.
Yes, Your Honor. I agree that at the time there was no fraud or gross, there was no ambiguity or fraud or gross inequity at the time that it was entered into. This court also, Your Honor, had several.
Ms. Cruz, what is the equity now in that house since Mr. Cruz is still continue to pay it? How much if it's sold today?
I'm not quite sure, Your Honor, what the inequity is, but I mean the equity in that property, but the value that the lower court had since I believe 2017 is $574,000, and that would the lower court found that that would be in compliance with Section C 1C provision of the stipulated decree. And so, Your Honor,
Loan balance today is. What is the loan balance?
I apologize, Your Honor, I don't have that information.
Okay, thank you.
So, Your Honors, this court also had several questions in regard to the default and the PFC loan. Just to clarify, what occurred in this case is that the PFC loan matured in June 2017. And so then there was the option of balloon payment and refinancing. Mr. Cruz demanded that Ms. Carmelita Cruz continue to provide her secured separate property. Of course, she was not required to do so, as this court correctly indicated during the argument, but that in January 2018, she was left with no choice because in February 2018, foreclosure was set. And so Ms. Cruz actually agreed to sign the new loan with Mr. Cruz. And when she agreed, Mr. Cruz indicated, I am not signing unless you pay the $5,000 fees. He frustrated it, Your Honor. Even though Ms. Cruz didn't have the obligation, in her desire to really protect her separate property, she agreed. And it was foreclosed because of those $5,000. Your Honors, I respectfully request, in light of all the arguments, that the court reverse and remand the decisions and orders in this case, and that provide instructions to award Ms. Cruz with $88,500 money judgment for her separate property, and also to find that the marital residence is modifiable and that there was gross inequity, and it's a modifiable term, and that there is gross inequity. Also, Your Honor, that Ms. Cruz was able to establish substantial changes in the circumstances to warrant a spousal support. And lastly, because of all the history in this case and the facts provided in the argument, she is entitled to necessary attorney's fees in filing all these motions, including this appeal. Thank you very much, Your Honor.
Thank you, counsel. Thank you, Attorney Cruz and Attorney Maher, for your arguments. The court will take the matter under advisement, and we now stand adjourned.
Thank you, counsels.
Thank you very much, Your Honor.